This is Sarah Frazier, an attorney with the Office of Bloch and Chapleau. The 6 most commonly asked family law questions by clients are: 1. Could I be common law married? 2. What is my exposure to maintenance or alimony? 3. How do I force my ex to abide by the court's orders? 4. How is the court going to divide our property? 5. What happens if a restraining order is filed? And 6. Is a paternity test needed? First, could you be common law married? The short answer to this is yes, since Colorado is one of the few states that still recognizes common law marriage. However, just living together, even for many years, does not make you common law married. Although living together is a factor, the main consideration is whether you have held yourselves out to the community as a married couple. This can be shown in several different ways, the most common being the filing of joint tax returns and maintaining joint health insurance. If it is determined that you are in fact common law married, you must get a legal divorce because there is no such thing as a common law divorce. Second, what is your exposure to maintenance? Maintenance is what the courts call alimony, and your exposure depends on several factors, including disparity in incomes, the length and standard of living during the marriage, and whether your spouse can meet their financial needs without your help, just to name a few. Maintenance is probably one of the grayest areas of family law and can hit you hard in the pocket if you are not fully informed or prepared. Third, how do you enforce the court's orders if your ex will not comply? Seeking contempt is your best remedy in such circumstances. Contempt can be remedied in many ways, ranging from simple compliance to fines and even jail time. If you are facing a contempt, it is highly advised that you seek the assistance of an attorney, as it could lead to severe consequences. Fourth, how is property divided in Colorado? A common misconception is that Colorado is a 50-50 or equal division state. However, Colorado is an equitable division state, meaning your property can be divided disproportionately if the court finds it to be fair under the circumstances. Fifth, what happens if a restraining order is filed? Although restraining orders are actually needed in some cases, people often use them for improper reasons, like to force the other person out of the house or even just to get a leg up in the divorce case. The biggest mistake you can make when facing a restraining order is to not hire an attorney and allow it to be made permanent, because what many people do not realize is once permanent, a violation is considered a crime. It may also show up on a background check, which may affect your job. It is also important that if you are served with a restraining order, that neither you nor anyone on your behalf contact the other party, as this could be considered a violation. Finally, is a paternity test needed? The answer to this question is always yes. If you waive your right to a test and admit paternity, your right to later request a test is forever waived. If any of these questions have crossed your mind, or if you are simply interested in finding out more about your rights in a divorce or other family law matter, contact Bloch and Chapleau to schedule a consultation.